I've got to say I've really enjoyed developing this talk, and I should say at the outset I've done that with Angela De Silva, who's here as well. Angela, you'll discover I've added lots of things since she last looked at this, but that's fine. I think together we'll see how we develop a paper afterwards. It is still very much in progress, so I really hope there are some interesting and useful comments at the end. Now, I've got things I can share screen. I might sort of start and stop doing that as we go. There's probably just a few bits where it helps. So let me do that. And you are now seeing the basic title, and you see myself and Angela there. So my title's really thinking about pluralism in relation to democracy and free speech, but you'll see I'm using a term that isn't just a pluralism, it's sustained plural public speech. And I'm going to talk about a bit about what I mean by that, and it comes out of the book that Charles mentioned. So in that book, I looked at a whole lot of things, but left aside European level courts. And so this opportunity to think about one or more of those courts was then interesting. And what I'm going to focus on is the European Court of Human Rights and what it says about pluralism, especially those bits that are relevant to media structures. And also then what it says about positive rights in general and some of the literature on that. And I'll really, I think, just get to the point that the court hasn't really articulated the idea of sustained plural public speech and what it's talking about, but that idea or parts of it, that idea is implicit in some of what it has done. Now, let's try that. Some, disclaimers. I'm going to be talking here about courts primarily, and obviously courts are not the only actors in relation to the positive dimensions of free speech. Legislatures, executives, regulators, journalists, a whole lot of entities are really important. That said, courts may well be a very important element, and I talk about that at greater length in the book. And it's interesting to focus on European court in that way to see what it has done and not yet done. But one could look a lot wider to think about this at the European level. The Court of Justice, obviously, but the European Commission, the European Parliament, the European Union Council. There's a whole series of initiatives, and more recently, that I think are just worth noting. So there's the Media Pluralism Monitor that the Commission has funded for a number of years. But then more recently, there's the Rule of Law mechanism, the Democracy Action Plan, the Media and Audio Visual Action Plan, the proposed Media Ownership Monitor, a pilot is happening. And in all of those initiatives, quite a lot is said about pluralism, some of which does go beyond the sort of market pluralism that one might immediately think of when you look at the European Commission. So I think that is another avenue you could look at, and over time it may become more significant in what it achieves. Okay, here, because it's out either this month or next, I'll show you the pretty cover of the book, but also because I want to say a little bit about what's in it, I think, to then make sense of what I say about the European Court of Human Rights. So the book as a whole is talking about a quality of freedom in free speech, the positive dimensions of freedom that I would argue are part of free speech in a democratic context. So free speech has positive dimensions of enablement as well as negative dimensions of non-restraint. Both need protection in democracies. Now, in this work, the book, I draw from media studies, human rights scholarship, political theory, free speech analysis by lawyers, and also German and French free speech case law to show how positive dimensions of speech could be imagined and pursued, and how courts might have a substantial role in that. Or in any event, the ideas that are set out could be used by other actors as well. Either courts or other actors doing that to a substantial degree is somewhat improbable. And really then the overall argument of the book is to say the democratic government faces challenges of public communication. which can't be easily addressed. But understanding those challenges and the role that the positive dimensions of free speech play, as well as the negative, at least makes possible what I call a democracy of expression. Prize to anyone who knows where I took that from, which I do explain in the book. It comes from Pierre, for the French in the audience, and one of his democratic analyses. And it is what he, and then I adapted, would say is a society, a democracy where society has a voice, formulates judgments, and makes effective claims of government. Right? It's a continuing democratic process, not purely focused on elections, among other things. But understanding that at least makes a democracy of expression possible with those challenges. Now, I draw from all that material and I set out something that I've called sustained plural public speech. And I've sort of done that just to avoid saying pluralism. And there might be a better label. As Kari Karppinen, a Finnish media studies author, has often said, pluralism is a well thought over term. And what I'm trying to emphasize in that different label is that it's sort of pluralism plus, right? And I'll get to what that means in a sec. But I've also added the word sustained. So I want to say just a little bit about what do I mean by plural public speech and what do I mean by sustained. Drawing from a wide range of sources, as I said, media studies models of what a democratic media would be, human rights literature on positive rights, etc. I end up with a very optimistic model or extravagant model of plural media. You'll see it's very long, right? But I can underline a few bits to help maybe. It's a structurally mixed media environment with multiple and varied institutional forms, particularly to note varied economic support, with transparency of ownership, control and content, aimed at different audiences and with debates aimed at a wide public as well as cultural and interest groups that are smaller. Right? I mean, in simpler terms, it's an environment with diverse media entities, diverse funding, diverse missions, and diverse people. And that people is the people making it, the people who are the subjects of the content, and the audience who's using it. Right? People in all those senses. Now, obviously, that sort of pluralism could only be achieved to a degree, but the argument I set out is how a reasonably substantial degree of it is needed to have what you would call a communicatively legitimate democracy. Now, what about sustained? Right? Public speech has been sustained in many ways historically, but a large part of that has been by the media. That's in terms of media structures. That's been important in how public speech has been supported, the shape of the industry, its financing, etc. And that has changed across decades and changed much more in the last decade. It's also been sustained by practices of journalism. Now, I need to note that content I'm interested in is not only news and commentary, but often the discussion in my own analysis just defaults to that because it's clearly an important part of what's at stake. Right. Now, I'm not saying that those former media structures or the journalistic practices were ideal in some sense, or even that they were necessarily very good in democratic terms, but they were significant. They influenced what existed in public speech. So they were important to political opinion formation. And my point by emphasizing that word sustained is just to say some form of sustaining public speech is often assumed in analyses, democratic analyses of free speech. And when people argue about we should restrict this speech or we shouldn't restrict that speech, they assume there's some model of public speech under it. Right? There is something that will support, in the classic US phrase, public speech that is, public debate that is robust and wide open, etc. Whatever that has been that's sustained public speech has changed. And the analysis I set out in the book is why some form of sustained plural public speech is required under a democratic Constitution. Okay, so that's a little bit of background. What about the European Court? What does it say about free speech and pluralism? Let me start with a simple quote from one of its cases where it does talk about positive dimensions of the freedom. It starts with the truism: there can be no democracy without pluralism. And I think what the paper will try and end up by saying is that if you understand pluralism in a fuller sense, a quote like that actually carries a lot of weight. It should prompt the court over time to continue to develop what it means by the positive dimensions of Article 10. But everything hangs on what's meant by pluralism there. So let's get to some examples. The standard starting point would be to note Article 10, paragraph 1 and paragraph 2 of it. Everyone has a right to freedom of expression, freedom to hold opinions, to receive and impart information. The exercise of that freedom can be subject to formalities, conditions, restrictions, right, that are necessary in a democratic society in the interests of various interests, including the rights of others. That's 1 and 2. Both important, but note 1, because I'll come later to how I think perhaps more than the court has generally said and said in relation to Article 10, the positive dimensions of free speech that I'm interested in arise under 10.1 and needed to be analysed under 10.1. But we'll come back to that. So when the court does talk about pluralism, it may be talking about it in relation to restrictions on speech, right? And that's a relevant use of pluralism. It's not the only one, and it's not the one I'm primarily interested in here. But you see it in a case like Handyside, you know, and others where they've said, you know, the protection is not applicable only to information or ideas that are favourably received, but also to those that offend, shock, or disturb. You know, that's the demand of pluralism, right? Not to restrict some speech. And there are debates over where that boundary would lie. But there are also statements that the state is the ultimate guarantor of pluralism. Right? It's empowered to guarantee and responsible for guaranteeing pluralism of public speech. Now that intrinsically involves positive obligations on the state. That pluralism is at times noted as being important for opinion formation in relation to politics. Yeah, as it said in Lingers, the freedom of the press affords the public one of the best means of discovering and forming an opinion on the ideas and attitudes of political leaders, that is, on their own political ideas, the public's own political ideas. And the freedom is not just the media's. Right? Not only does the media have the task of imparting such information, the public has a right to receive them. So it is in part a freedom of reception, as it would be called in the French tradition. Now, the court's interest is much more clearly seen in relation to audiovisual media. That fits with long traditions across Europe. So you see in the Manola decision, the state has a duty to ensure the public has access to impartial and accurate information on a range of opinion, and journalists and other professionals are not prevented from imparting that information. Right? A duty that the information is there and that the professionals are not restricted. That is positive and negative dimensions of the freedom that is described in Article 10. And so you end up with some quite, impressive quotes from Centro Europa 7. And the court says, in such a sensitive sector as the audiovisual media, as well as the duty of non-interference, there's a positive obligation to put in place an appropriate legislative administrative framework to guarantee effective pluralism, or similarly in Manola. genuine, effective exercise of freedom of expression may require positive measures of protection through the state's law or practice. Now, to go back to that Central Europa case for a sec, the quote, you see, if those words I've underlined were actually just taken at face value, they look quite powerful. An appropriate legislative and administrative framework to guarantee effective pluralism. But it is worth noting that right when the court says that, it refers back to an earlier paragraph in the judgment, which really emphasises the commercial pluralism, the market access aspect, right? What they mean is you need to allow effective access to the market, because that was the issue in Central Europa, so it's understandable they emphasise it, but the way that's done could be read as saying things don't go any further. Right? And I think things do go further, should. The implication in the paragraph 130 quote I've got up there is that the diversity of content that would reflect as far as possible the variety of opinions encountered in society is achievable through access to the market alone. And lots of analyses would say that's unlikely to be the case. And I appreciate the exact question didn't arise in that decision, but the way the court frames its analysis, which fits with its tradition as a court overlying all these national courts, the way it frames its decision, just like to see it go further, and I think over time it might. Now, so I've said there are some impressive quotes, one might say, still often with a commercial focus. But it's also worth noting a few more points before I get to positive rights in general. Now, of course, when the court is talking about such obligations, they will know the obligations vary depending on the circumstances and the context. Choices must be made. Right? One could read that to mean choices must be made by the relevant state authority. And I'll come back to that in a few minutes. Another point to note is the way the court will move into proportionality analysis when it's talking about these requirements. Now, proportionality analysis will make sense when you're analysing the negative dimensions of the freedom, and the case I've noted up there, the ATV, ZRT and Hungary decision is a recent example where there was media legislation that was ostensibly aimed at ensuring media pluralism, but it led to the penalties being applied to a media entity and journalist, and in fact the court analysed as whether it was an allowed or not allowed restriction under 10.2, and thus you get to proportionality analysis, because the issues you might be aware about whether far right would be seen as a matter of opinion when described, when a political party was described in that way, or not. And if it was opinion, it would breach the relevant Hungarian law, which required news content to be facts or to label clearly any opinions. But when you're talking about the positive obligations more fully, proportionality analysis just doesn't make a lot of sense. And I'll come on to this more generally in relation to other aspects of positive rights under the European Convention. Look, another point to note is the position of public broadcasting. And again, the court has in a number of instances said how public broadcasting is optional. It's not requiring that. You might guess, seeing I mentioned the book analyses German and French decisions at some length, and particularly the German decisions on broadcasting freedom, would take a very different view. And they're basing that on a positive dimension of free speech. And so I think there's some questions about the optionality the court arrives at, But you see also in the case of, I forget the individual's name, and Prosper, which was the union, and Greece, which was about the Greek public broadcaster being disbanded and then an interim broadcaster created during financial crisis. And the case was ruled inadmissible, the claim. And I think why that happened is also interesting and reveals challenges in the positive aspects of Article 10. So the court said this claim was inadmissible because the applicants didn't meet the victim status requirements under the convention, under Article 34. And they said the mere existence of legislation affecting all Greek citizens, that is, ending the public broadcaster, is not sufficient to establish the applicant's victim status. I mean, if you read the decision, if they had chosen a different applicant, a journalist, rather than a person who worked in the broadcaster but wasn't involved in producing content, they may have actually got a different result. So it's a strange situation, right? The court said the mere fact the applicant could no longer watch or listen to the programs previously broadcast by the public broadcaster does not suffice to establish a direct link between the law that shut down the broadcaster and the applicant. And so one of the questions that flags is that if the public has a right to receive a wide range of content, which is implicit in other statements the court makes, who represents the public for claims under the European Convention? And I think that really is an issue that applies in any legal system that's going to deal with these positive dimensions, but it hasn't really been flagged for the court as much as it should be. Now, all of that said, there is still application of these ideas, and Manole is one that's often referred to. And I put extraordinary question mark application on the slide because it's debatable whether the statements that are made by the court are made only because of the, I think, reasonably extraordinary situation that applied in terms of the government control of the public broadcaster and the public broadcaster's virtual monopoly or overwhelming dominance of the media market, or whether they suggest things that might develop more generally for the role of a plural public media within a plural media system. So the court in Manole said it's essential for the state's law to put in place a legal framework which ensured TRMs, the broadcaster, ensured its independence from political interference and control. And the law had failed to do that, including amendments to the law that had been made after some initial debates about it. There was no guarantee of political balance in the composition of the broadcaster's management and supervisory body, nor safeguard from interference in those bodies by the ruling political party. Right? And this breached Article 10. The state authorities failed to comply with their positive obligation. But this is where there was interference and there was a virtual monopoly, the court said, over audiovisual broadcasting in Moldova. And so the query is quite which elements of that decision would stand without quite that degree of political interference or quite that degree of dominance. Now, that's a little bit on what the court has said so far about Article 10. And I think to understand it better, it's worth to taking a step back or step aside and thinking about positive rights in the European Court of Human Rights more generally. And I'm not going to do a huge analysis of this. I'm going to use one source in particular to talk about really its positive dimensions of rights. Right? And I'll do it by drawing on Dimitris Xenos. It's a study from about 10 years ago, the positive obligation of the state under the European Convention. Now, his focus is actually somewhat different than my own, but even so, I think there's some really interesting and useful points that can come out of this work. He's interested in setting out how positive rights can work in law. how can the court develop its jurisprudence? But mainly in relation to private parties affecting another's convention right, what's often called indirect horizontal effect, and in relation to the state's obligations to vulnerable individuals. And he's looking at both the sort of substance of these positive obligations and the procedural aspects of their protection, focusing on claims by individuals who it would appear would meet the Article 34 requirements under general analysis. Now, I think if the positive dimensions are more fully understood, there are wider questions about standing to consider. But there's also another dimension to positive rights beyond the horizontal effect and, say, the vulnerable individuals, which is what he is focusing on. He notes it but leaves it aside, and I'll come back to that because I think it's relevant to my interest in Article 10 and rural public speech. So he notes, as other analyses would tend to, it's not just the particular article in question, Article 10 for me, but it's the convention as a whole, and starting, for example, with Article 1. And I just thought this was worth noting, because I'd be interested to know actually whether the French speakers in the audience see this point or agree with it. But he notes both the French and English versions of the convention, noting they're both seen as authoritative, but that in Article 1 they differ, that the English is the high contracting party shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1. Right? So that's all those subsequent articles. And in French, it's les autres parties contractantes reconnaissent à titre personnel, etc. Right? And so he notes and makes the claim it's widely accepted the English version of shall secure these rights rather than the recognise, which would be the literal French meaning, that it's the English one that expresses the real scope and potential of the convention. And it's a difference I hadn't noticed before, so that's one somebody could comment on later if they want. But the main point from that is simply the convention as a whole sets out in various articles the idea of positive obligations. He then runs through some cases, and it's worth saying a little bit about one or two of them. Marx, 1979, is where the court states the obligations are inherent in Article 8. That's where the private life and a broad approach to private life became relevant. So the court said there may be positive obligations inherent in an effective respect for family life. So you see the idea of an effective enjoyment of the right, and here family life as part of Article 8's private life. It continued, the state has a choice of various means, but as a law that fails to satisfy that requirement of an effective respect for family life violates 8.1 without there being any call to examine it under 8.2, the allowable restrictions. So the key point to take from that is not that that legitimate limitations can't be justified. They might be. That could be under separate issues that will arise in a particular case. They're just not relevant to this initial question of the effective enjoyment of the right. So his analysis then continued. The only possibility to restrict the protection that was discussed in Marx under paragraph 1 would be to show the convention right hadn't been engaged in the circumstances. So what's the scope of the right and when would it apply? Or the cost of protection would be disproportionate and impractical. And both of those, the scope of the right and the practicality issue, need further consideration, which I'll come to. Now, I said he focuses on, Demetrius focuses on third parties infringing rights and the state's obligations in relation to that, and vulnerable individuals. But there's another aspect. He discusses this by discussing Clotilde, I think, a book that in English, the title would be Positive Obligations of States. So again, very similar scope another 10 years earlier, roughly. And it classifies the positive obligations of rights into horizontal and social categories. Horizontal is the protection of human rights between private parties, and social are economic and social rights as they're normally described, rights to housing, etc., but also rights to legislative action, for example, to enact the laws necessary for the enjoyment of a right in a given national system. Now, Robert Alexy says basically exactly the same thing, and I think it's the German origins of both these writers, in relation to broadcasting freedom under the German constitution. Right? He describes positive rights as being of three types: protective rights, protecting the state protects individuals against non-state actors; social rights, as commonly understood; and what he calls organisational and procedural rights. And this means the legislature and other actors like the executive, etc., don't have an entirely free hand. They're constrained by these organisational and procedural rights. They're a form of positive right that the, to quote him, legislature passed certain organisational norms consistent with the Constitution. And so it's this aspect of positive communicative freedom that I think could be brought out more in Article 10. And it's implicit in some of what the court's already said, but the actual implications haven't really been relevant in those decisions. Okay, so there, I meant to put that forward before, this rights to legislative action, which he notes but leaves aside, and I don't think sees the significance of, and for his focus, it's not so significant. Now, there's a few more points to take from Dimitris about positive rights in general, Xenos, I should say. One is he has quite a good discussion of the fair balance test. As you might know, the court often uses the idea of fair balance when it's talking about positive dimensions of rights. In determining whether or not a positive obligation exists, regard must be had to the fair balance that has to be struck between the general interest of the community and the interests of the individual. And I mean, I would say, and I think it's more or less what he gets to as well, that the idea of the effectiveness of the right, the effective protection of the right, may be a better test than fair balance. One of the other points he raises is the use of margin of appreciation. And this comes back to something I said quite a bit earlier about these dimensions of free speech arising under Article 10.1. They may also arise in relation to restrictions under 10.2, but they do arise under 10.1. Right? And how I said the court says, oh, there are choices to be made. There's resources to be allocated, these sorts of things. Right? It's a choice of measures to guarantee the active protection of human rights under paragraph 1, which isn't the same as the margin of appreciation in the proportionality analysis under paragraph 2. Now, the court's done various things to suggest, and some dissenting judgments or concurring but separate judgments have suggested ways you could deal with this. I actually think the clearest way to deal with it is just to say this arises under 10.1 and it is a distinct issue. You don't need to shoehorn the full proportionality analysis into it. It's more that necessarily when there are issues, say, how will the state support a plural public media system? It could do many, many different things. It can't do all of them at once. It doesn't need to. It just needs to do sufficient to arrive at a version of what I described as plural public speech near the outset. And that involves choices and involves a discretion, but it's not necessarily the same as the margin of appreciation. It's a different discretion and choice that would be available to the member states under the European Convention system. Now, I also flagged earlier that his analysis emphasises how the positive applications will arise in relation to rights. So often the first paragraph of the right is his argument. So that it would be 10.1. So you need to work out, well, what is the scope of that right? And then there are going to be limits of practicality. And the scope has a conceptual aspect about the human right concerned, and that's where I think the broader analysis of what free speech is, and there's a wide range of literature that talks about positive dimensions of the freedom, could be relevant. And also the degree of impact on the individual that results from the fact that this positive dimension of the right is not being supported. And he notes that can involve a sort of hierarchy of rights analysis, and the court will do this in relation to positive rights in general, the rights to life obviously being primary. But also it is worth noting, as national courts, and the German court in particular would note in relation to speech, that speech is particularly important also when assessing other rights, because of public speech's importance in democracy and democracy's role in supporting other human rights. So it has a particular foundational impact. Okay. Now, oh my God. I've got a whole lot more I could say, but I think I'm going to try and say it very quickly because I'd like to hear what people think. And that is to come back to what I've said in the book about French and German law, because it models some of the things that I think could develop. I think to a lesser degree, because the European Court will be cautious in trying to see any common European standard that it could articulate in relation to Article 10. But although they're not entirely overlapping bodies, the way in which various other entities in the European Union are discussing pluralism in broader terms, I think might help that in time. Pluralism does have this wider meaning and an audience-focused meaning that I think the European Court could draw on. But let me just run through a couple of things quickly. So in the book, I study German and French decisions at length. And I say, look, in the end, they've got some real similarities. They're both talking about a facilitative model of free communication in which diverse public speech is a precondition to democracy. They're interested in what are the conditions for the effective exercise of that freedom. They're interested in audiences as much as speakers. Both are relevant to the freedom. They're interested in the way the freedom supports opinion formation, and particularly political opinion formation for democratic decision. And they're interested in freedom from state and market domination. The freedoms are broad, and it's worth noting they are more or less enduring. That is, the legal analysis have not changed greatly despite the huge changes in media systems and uses since the ideas were first articulated. Yeah, but there are differences in relation to the understanding of public broadcasting, in relation to the approach to funding, in relation to regulatory independence, and what I call the precautionary approach. Now, I could talk about those more, but I won't. I'll just say something very quickly about these two I've underlined. I think the German example is really interesting for the way the court emphasizes the requirements for it to act to support what I would call an environment of plural public speech, at least in relation to broadcasting, because the decisions cannot be left purely to politicians. The conflicts that they face, politicians, are too great and too risky. Therefore, the court has to set baselines. And I think the arguments that it sets out could well have wider application, but aren't picked up by other courts. And I think out of the French example, what's really interesting in it is the way you can see how pluralism is both a counterbalance to freedom of communication in some ways, but is also a part of the freedom of communication. It's an objective, a constitutional value that makes the freedom effective. And I think the analysis that you can see in some of the French literature that explains that, which I've hopefully done some service to English speakers by describing it in English in the book, shows how the pluralism has both aspects. And I think that's really important because, as you might have realised, implicit in everything I've said up to now is I'm treating pluralism as an integral part of free speech, not as another interest set alongside freedom of speech. Now, I think I can stop sharing. I think that's more or less what I wanted to say, and I'm not quite sure how all of this will get pulled together, but I think it's basically a bit more on what the European Court has said in Article 10 terms and in general about positive dimensions, and different ways that that could be extended through the ideas of plural public speech more generally. I think that's what I wanted to say, but make clear in that in fact there's a lot of other stuff going on in Europe that also could develop in really important ways over time. Thank you.